Okay. Hi, my name is Kathleen Bennett. I'm a partner with the law firm of Schoeneck King. I've been practicing eminent domain law for about 20 some odd years now. So I thought this would be a good topic for a webinar, especially with the spring development season approaching. So just a brief overview. First, I'm going to talk a little bit just about what eminent domain is. We'll walk through the statutory procedures, spend a little bit of time talking about the concept of public use, and discuss how developers can benefit from a public agency's power of condemnation, and then spend a little bit of time on negotiation and valuation of property for the purposes of determining just compensation. So what is eminent domain? Eminent domain is the power of the state as the sovereign to take or acquire private property for public use or public purpose without the consent of the owner whenever necessary, provided that due process is provided to the owner and just compensation is paid to the owner. So the power of eminent domain is an inherent power of the state, founded upon the principle that the interests of individuals are subordinate to the public interest, and that those interests must yield when the public welfare requires it. So the power is limited only by the state and federal constitutions, and I've put those provisions up on this slide. And those provisions require that the acquisition of private property must be for a public use, require the property owner to have notice and an opportunity to be heard, so due process, and require that the property owner receive fair market value for the property of the property acquired, or just compensation. And in New York, who has the authority to condemn? So in general, only public entities have the power of condemnation, including the state, its political subdivisions, such as county, towns, and villages, governmental agencies, such as the New York State Department of Transportation, public authorities, such as the New York State Thruway Authority, various water authorities, sewer authorities, transportation authorities, public benefit corporations, such as urban renewal agencies and industrial development agencies. So the New York State Public Authorities Law creates local and regional authorities and imbues them with the power of eminent domain to serve their purposes for which they were established. It's the same in the general county law. Counties may condemn property for lawful county purposes, and there are similar provisions found in the general town law, the general village law, and the general city law. The general municipal law is what gives the power to IDAs and URAs to condemn property. And then the Transportation Corporation Law gives an entity that organizes pursuant to that law, as an electric corporation or a gas corporation, the power to condemn to fulfill its corporate purposes. So that's how utilities typically obtain their powers of eminent domain, is by organizing pursuant to the Transportation Corporation's law, and can condemn for those purposes. And there are two types of condemnation. For purposes of this webinar, I'm going to be spending, all of my time talking about direct condemnation. And that's, when a public entity seeks to acquire property and uses the procedures set forth in the eminent domain procedure law to do so. There is also something known as inverse condemnation. And that's when some type of government act or regulation inadvertently takes the value of an owner's property. So I'm not going to spend a lot of time on that, but be aware of that, that there are claims out there and a lot of case law out there that deals with this concept of inverse condemnation. So we'll spend a little bit of time on an overview of the acquisition process. So the EDPL, the Eminent Domain Procedure Law, provides the exclusive procedure by which property may be acquired by eminent domain. It was designed to establish an opportunity for public participation in the planning of public projects, to ensure that the condemnor considers the need to acquire the property for public use, the interests of private property owners, local communities, and the quality of the environment, and to ensure that just compensation is paid to those persons whose property rights are acquired by eminent domain. It was also established to encourage the settlement of claims for just compensation and expedite payments to property owners, to establish rules to reduce litigation and ensure equal treatment to all property owners. So to satisfy these very lofty goals, the eminent domain procedure law requires that the condemning agency hold a public hearing on proper notice to the potential condemnees and the public at large. The purpose of the public hearing is to inform the public and review the public use to be served by the proposed project and the impact of the project on the environment and on area residents. Within 90 days of that public hearing, the condemnor must issue its determination and findings, and that provides the condemnor's rationale for the project. The public uses to be served, the reasons for selecting that proposed project location, and the impacts of the project on the environment. The EDPL also requires the condemnor to make a written offer to the condemnee for the full value of the property acquired. The offer should be based on the highest approved appraisal report obtained by the condemnor. And whenever possible, that offer should be made in writing prior to acquiring the property. And I'll go through these steps in a little bit more detail as we move through the presentation. So the EDPL also provides the condemnor with access to the property prior to acquiring title for the purposes of making surveys, taking test pits and borings, and other investigations. There's also a provision for temporary occupancy when necessary. Within 3 years of the issuance of its determination and findings, the condemnor must file acquisition maps. That's done typically by presenting a petition to Supreme Court and requesting permission to file those maps. And then with respect to making claims for additional compensation, so when an offer is made to a condemnee, they can choose to accept that offer as payment in full, or they can choose to accept that offer as an advance payment, or they can reject the offer in its entirety. If they accept the offer as an advance payment or where they reject the offer, then the condemnee can file a claim with Supreme Court for that additional compensation. Typically, claims must be filed within 3 years of the filing of the acquisition map, unless a shorter period of time is provided by the court. So the public hearing requirement is set forth in Section 201 of the EDPL, and it states that prior to acquiring an easement or any other property, a condemnor must hold a public hearing, and that hearing must be conducted at a location that is reasonably proximate to the property which may be acquired for the project. So in order to allow for the people who are going to be most impacted by the taking to attend, they really want this hearing to be held in close proximity to the property that's proposed for the taking. There are certain exemptions to the hearing requirements. One is where the condemnor considers and submits factors similar to those found in the EDPL as part of some other public hearing process before a state, federal, or local governmental agency, board, or commission in connection with obtaining a necessary license, permit, certificate of public convenience or necessity, or other similar approvals from such agency, board, or commission. There's also that specific provision written for condemnors who obtain certificates of environmental compatibility and public need from the Public Service Law. So most public utilities will be exempt from public hearing requirements for those projects for which they're seeking an approval from the Public Service Commission. Other exemptions are provided if the acquisition is de minimis in nature, or where the public interest will be endangered by holding a public hearing because of some emergency situation. So an example of something that's de minimis was where there was a proposed taking by the county to straighten and flatten a strip of road that was less than 1/2 mile long. And that was determined to be de minimis. The taking involved only 1.94 acres of petitioners' 79.5 acres of land. The land to be taken included only narrow strips abutting the present roadway, and the taking would not interfere with the current land use and did not require the removal of any structures. So that's just an example of something that can be considered de minimis and not required to go through the public hearing process. When a public hearing is required, the condemnor must give notice of the public purpose, time, and location of the hearing, must set forth the location of the public project, including any proposed alternate locations, and that notice must be given at least 10, but no more than 30 days prior to the hearing. The notice must be published in an official newspaper, an official daily newspaper, for 5 successive issues. And you also must, the condemnor also must mail notice to the owner of record, and that's based on the assessment record billing owner. So you don't necessarily have to search to the ends of the earth to figure out who to send the notice to. You just go to the assessment records and send it to that individual. At the public hearing, this is the creation of the record to support the condemnation. So the condemning entity really should make a strong presentation of why it needs to acquire this property through condemnation. So the condemnor is going to outline the purpose for the taking. It's going to talk about the proposed location and any alternate locations that were considered for the project, and any other information that it considers relevant as to why that the property must be acquired. There should be maps included, property descriptions should be included. I always, when I have represent an agency undertaking a condemnation, make sure that there's a map set up and visible for the entire duration of the public hearing. So that way people know exactly what's proposed to be taken, and they can't say that they somehow didn't know what property was being considered for acquisition. Once the condemning agency is done making its presentation and basically establishing the record it believes is sufficient to justify the taking, then any person who attends the hearing must be given a reasonable opportunity to present an oral or written statement and to submit any other documents concerning the taking. So they can put in whatever they want. A condemning agency is allowed to limit the speaking time for each of these individuals. Typically 3 to 5 minutes is appropriate to allow individuals to speak and present their case at public hearings. A record of the hearing shall be kept, including any written statements that were submitted. So I always get a court reporter or someone to come in to do the hearing record. And I often, when I'm representing, and actually even when I'm representing property owners, if I submit exhibits, I actually make a note of submitting and identifying exhibits for purposes of the record. So copies of that entire record must be available to the public for examination without cost during normal business hours at the condemnor's principal office and the office of the clerk of the county in which the property is proposed to be acquired. That's always interesting sometimes, because you'll take this record down to the county clerk's office and they'll look at you with this quizzical expression on their face like, what am I supposed to do with this? So you should also take a copy of the EDPL provision with you that says that you have to leave a copy with them. Copies also should be reproduced upon written request and the payment of any cost associated with reproduction. And then if necessary, if the hearing has to be adjourned, then further adjourned hearings should be scheduled. Once the hearing is closed, the condemnor has to make its findings and determination within 90 days. And that public hearing, or that findings and determination, also has to be sent to the owners of the property proposed for condemnation, and a brief synopsis of the findings and determination must be published in 2 successive issues of an official newspaper of record, and also mailed to the billing owners or their attorney of record. Now, the notice and synopsis of the determination and findings must also identify that there's an opportunity for judicial review. And the eminent domain procedure law very specifically sets forth how that notice is to appear in the synopsis that is sent to the property owners, and it must appear in bold and all caps, et cetera, et cetera. So make sure that you look at that language in the EDPL as to provide proper notice about the opportunity for further judicial review. And what are the factors that the agency must rely on in making its determination and findings? Those are the factors listed here. So they have to consider the public use, benefit, or purpose to be served by the project, consider the approximate location for the proposed project, the reasons for the selection of that location, so any alternatives that were considered should also be discussed in the determination and findings. They must consider the general effect of the proposed project on the environment. Typically, these decisions are going to be subject to environmental review under the New York State Environmental Quality Review Act. So those findings under seeker can suffice for the environmental findings that must be made as part of the determination and findings, but they should be referenced in this very specific determination and findings document that the condemning authority is going to issue. They should also consider the general effect of the project on the residents of the locality and any other factors that the condemnor considers relevant. So with respect to judicial review, any person or persons who are jointly or severally aggrieved by the condemnor's determination and findings, so typically the condemnees, may seek judicial review in the appellate division in the county where the property is located. And that petition challenging the findings and determination must be filed within 30 days after the completion of the publication of the determination and findings. The petition must be accompanied by proof of service of a demand on the condemnor to file with the appellate division a copy of a written transcript of the record of proceedings before it and a copy of its determination and findings. Once the condemnor has received the petition and the demand, then it must deliver to the appellate division a copy of the record and a copy of its determination and findings, and the proceedings in front of the appellate division are heard on the record that the condemning authority used to make its decision. So these proceedings are supposed to be determined as expeditiously as possible, but it's been my experience that you often need to make a motion to the appellate division to expedite these proceedings. And even then, it's not always the most expeditious, as the appellate division 4th department in particular is very backed up right now with its caseload. So it is doing very little expeditiously. But nevertheless, the statute says that they should be determined as expeditious as possible. The scope of review in front of the appellate division is limited. So the appellate division can only consider whether the proceeding was in conformity with the federal and state constitutions, that the proposed acquisition is within the condemnor's statutory jurisdiction or authority, that the condemnor's determination and findings were made in accordance with the procedures set forth in the EDPL and with seeker, which is Article 8 of the Environmental Conservation Law, and that a public use, benefit, or purpose will be served by the proposed acquisition. So let's spend a little time on public use. There is no universal test, and that term has been defined broadly as a purpose or use necessary for the common good and general welfare of the people. So there's no requirement that the property taken actually be used by the public. For example, the taking of property by the government to enable to carry out its public functions and to conserve or protect the safety, health, and general welfare of the public is a public use, even though individual members of the public may not make use of the property. In fact, the EDPL actually provides that property may be taken for a public use, benefit, or purpose. So general municipal law establishes local urban renewal agencies and permits them to acquire real property by condemnation. And they can acquire air rights, easements, any other rights necessary for the use and development of the property, for the elimination of blighting influences over an area or areas, and they can condemn other similar facilities which have a blighting influence on the surrounding area, but that must be necessary for or incidental to any urban renewal program that's part of an urban renewal plan. The general municipal law also established industrial development agencies, and the purposes of those agencies are to promote, develop, encourage, and assist in acquiring, constructing, reconstructing, improving, maintaining, equipping industrial, manufacturing, warehousing, commercial, research, and recreation facilities, and thereby to advance the job opportunities, health, general prosperity, and economic welfare of the people of the state of New York, and to improve their recreation opportunities, prosperity, and standard of living. So for those reasons, an IDA is equipped with the power to condemn property pursuant to the eminent domain procedure law. So while Kelo was a controversial decision when it came out in 2005, sort of on a national level, and in Kelo, the United States Supreme Court held that a city's exercise of eminent domain power in the furtherance of an economic development plan satisfied the public use requirement, even though the property would not be available for use by the general public. That was really nothing new for New York, because the New York State Legislature had already granted the power of condemnation to IDAs and urban renewal agencies for the purpose of economic development and rehabilitating blighted areas. And courts have upheld such uses in New York since 1936. So not really controversial in New York, because that's the way New York has always allowed condemnation to occur. And there have been other more recent cases that uphold condemnation for these purposes. So there was a case back in 2009, it was a matter of Goldstein, and there the New York State Court of Appeals upheld a determination by the Empire State Development Corporation to use its power of eminent domain to take certain privately owned properties located in downtown Brooklyn for inclusion in a 22-acre mixed-use development proposed and to be undertaken by a private developer. The Empire State Development Corporation found that the area in which the project was to be situated was substandard and insanitary, and that the proposed project would serve a public use, benefit, or purpose by improving a blighted area. That project included the construction of a sports arena, various infrastructure improvements, including reconfiguration and modernization of rail facilities, and access upgrades to the existing subway transportation hub, numerous high-rise buildings that would be used for commercial and residential purposes, including some affordable housing units, and some 8 acres of open, publicly accessible landscape space. Not long after that, in 2010, the Court of Appeals upheld a taking of private property to generate a new campus for Columbia University. And that was the New York State Urban Development Corporation that did the condemnation for that project. That would allow 16 new state-of-the-art buildings, the adaptive reuse of existing buildings, and multi-level below-grade support space. Again, the court rejected the appellate division determination that the project was private and instead held that the findings that the project qualified as a land use improvement project that would improve a blighted area were rational and based on the evidence presented. So the implication of cases like Kelo and its New York progeny and the general municipal law provisions is increased potential for public-private partnerships. So in those types of cases, private developers can approach urban renewal agencies, can approach IDAs to condemn land for the purpose of a private development project that would provide a public benefit to include economic development, jobs, or reducing or eliminating blight. In some instances, there may also be the opportunity for the private developer to benefit from the availability of joint benefit funds from the project or other tax incentives associated with the project, such as entering into a pilot agreement for projects with the IDA. So I will also note here, however, that an IDA's authority to condemn does not extend to not-for-profit civic entities or projects. So IDAs can condemn for for-profit entities and developers. URAs have the authority to condemn for civic projects, such as projects for universities, projects for hospitals, provided that those projects fit within the urban renewal plan for that area to eliminate blight. So getting back to the process, so once the public hearing has been held and the findings and determination has been issued, then typically that's when an agency will reach out to a property owner to negotiate and make an offer to acquire the property. So, this can occur before the hearing. It doesn't have to occur before the hearing. It can occur after the hearing. It actually doesn't even have to occur before you file your petition requesting permission to file acquisition maps, but it should. And really, the condemning authority should make every reasonable and expeditious effort to justly compensate persons for such real property by negotiation and agreement. New York courts do not require that a petitioner plead or approve as a prerequisite to the acquisition of property that it negotiated in good faith with the property owners. There have been cases where I've seen this raised as a defense, and it typically doesn't go anywhere as long as there's some kind of offer made. That is typically sufficient. When you make that offer, you're establishing the amount which the condemning authority believes to represent just compensation. So get an appraisal. You don't want to guess, because one, the EDPL requires the offer to be based on the highest approved appraisal. And also because if you don't get an appraisal and you guess low, then you could be required to cover legal fees and other fees associated with the condemnee's claim for just compensation if the award issued by the court is substantially in excess of the amount of the condemnor's proof and where it's deemed necessary by the court for the condemnee to achieve just and adequate compensation. So if you're low, there is a risk that you could be on the hook of paying for all of the condemnee's legal fees and expert appraisal fees in connection with their claim for compensation. So make sure you go out and get that appraisal and that your offer is for 100% of that appraisal. Again, wherever practicable, make the offer prior to acquiring the property, and wherever practicable, that offer should include an itemization of the total direct, total consequential damages, and benefits as each may apply to the property. One other note before moving on with respect to that appraisal. So if you get an appraisal to establish your offer, that doesn't have to be your trial-ready court appraisal. It can be a preliminary appraisal report at this point, and it also doesn't need to be shared. When I'm representing condemning entities, I typically do not share appraisal reports because there is case law that basically says that providing those reports in advance of the appraisal exchange date, which is set by regulation or by the court, gives the other side an unfair advantage because they know what your appraiser is thinking. They know what comparable sales they've relied on in making that determination. So I typically don't share the appraisal report. Sometimes I'll let a party look at a portion of it, or share it during a sit-down meeting. I'll let them flip through it, but I never generally let them keep a copy of it for any reason. So with respect to making that offer, if the owner is willing to transfer the interest but can't agree upon value, then an advance payment can be used and the owner permitted to file a claim seeking additional compensation. Or if the owner was not willing to transfer the property interest and you file your acquisition map, but you want to limit your exposure to interest payments, then you would also seek to enter into an advance payment agreement with the condemnee, whereby they agree to accept some portion of compensation, and then they can file a claim later on for additional compensation. If you're dealing with the New York State Department of Transportation, typically an offer of advance payment is the first notice of condemnation that you receive, as they have sort of a separate statutory expedited process in order to take property associated with transportation projects. And so this is where we discuss they can either accept the payment as an advance payment or reject the payment in full and later file a claim for additional compensation. And if they elect to claim additional compensation, then typically that claim must be made within 3 years of service of the notice of acquisition, or sometimes the court will set a shorter period of time, and failure to file a claim within either the 3 years or any shorter period of time established by the court is deemed to be acceptance of the advance payment as payment in full. So if you're negotiating with a property owner and you send them an offer and you don't hear from them within 90 days, then that offer is deemed rejected. And if the offer is rejected or deemed rejected, then the obligation to pay interest is suspended until either the offer is accepted or until appropriate papers and information are supplied that would allow you to undertake an appraisal and make an appropriate offer. And so that gets us into the next slide, which is access to real property prior to condemnation. So Section 302 of the Eminent Domain Procedure Law requires property to be appraised on behalf of the condemnor by an appraiser. And in order to prepare such an appraisal on which the condemnor's offer is to be based, then the condemnor has the right to inspect the property prior to vesting. And the owner, his agents or employees or tenants or other occupants, shall, on reasonable notice by a written request of the condemnor, provide any pertinent data or information, including books and records necessary to prepare such an appraisal. And so that goes back to the previous slide, whereas if they don't provide you with the appropriate papers to undertake an appraisal, then interest is suspended until that information is provided. And that's the point that I just made, is that the failure of an owner to comply suspends the condemnor's obligation to make an offer, and also suspends any interest. Upon notice, the condemnor also has the right to enter land prior to condemnation for making any surveys, taking any test pits, borings, or other investigations. That's provided by Article 4, specifically Section 404 of the EDPL. Again, this has to be on notice. Objections to entry by the property owner have to be dealt with. Sometimes they refuse, and if they continue to refuse, you may need to go to court with an order to show cause to get access to the property for the purpose of undertaking surveys or test pits or any borings. And then also keep in mind that the condemnor is liable to the owner for any damages caused as a result of the entry. And so when you're ready to actually acquire the property, you would seek to file acquisition maps. And this must be done within 3 years of publication of its determination and findings, or the date of the order or completion of the procedure that constitutes the basis of the exemption. So what that means is that for utilities, if you get the certificate of public need, that you have 3 years from the date of that order to file your acquisition maps, or 3 years from the entry of any final order or judgment on judicial review. So if the proceedings in front of the appellate division take a long time, that would give you additional time to file your acquisition maps, because it would be 3 years from the date of that order. So title to property vests upon the filing of the acquisition map with the county clerk. Every county seems to handle this a bit differently. Some won't file a map by itself. It has to be attached to an order or some other document. If you're looking for an easement, it's easy to attach the map to the easement. My practice is typically to file the court order authorizing the filing of the acquisition map together with the map, and then also to file the map and any terms associated with it, for example, in the case of an easement, separately, and then cross-reference those documents to each other. There are various fees associated with this filing, so those fees aren't often the easiest to calculate. So always make sure that you take some extra cash just to be sure that you can cover whatever those filing fees turn out to be. So the process for filing that acquisition map, it depends on whether you're the state of New York or whether you're another entity. So the state of New York must file in the main office of the agency, department, or authority or public benefit corporation for which the acquisition is being made the original tracing of the acquisition map. The state must then file a copy of the acquisition map in the office of the county clerk or register of each county in which the property is located. And at that time, the acquisition is deemed complete and title vests in the state. The state must notify condemnees by first-class mail that the condemning party is now taking steps to acquire the property, and then file a certified copy of that acquisition map in the office of the county clerk. Everybody else needs to obtain an order to file the acquisition map. And that's done by presenting a verified petition to a Supreme Court in the judicial district where the real property is located. And then upon receiving that petition, the court will determine whether the condemnor has satisfied each of the requirements of the EDPL, and if so, authorize the filing of the acquisition maps. At the same time that the petition is filed, the condemning authority should also file a notice of pendency with the clerk to put everyone else on notice that that property is subject to a petition for acquisition. So that way there aren't other interests that come on record while that petition is being considered by the Supreme Court. Again, in here, title to the property vests in the condemnor upon the filing of the acquisition map with the county. Once you get that order and file the map, you also need to serve notice of acquisition on the property owner and publish notice of acquisition in the paper for 2 consecutive days. The notice must include language that identifies the condemnee's time to file a claim for just compensation. So now we'll talk a little bit about filing that claim for just compensation. So in takings filed by the state in the Court of Claims, so typically your Department of Transportation condemnations, those claims must be filed within 3 years. A taking by anyone else in Supreme Court, 3 years is the maximum, but the Supreme Court can set a shorter period of time in which claims must be filed. So the payment of just compensation is required by both the federal and the state constitutions. But how is just compensation determined, and what exactly is just? So typically, the condemnor establishes the initial value of the property in its offer to the property owner. The offered amount is generally based on that appraisal report prepared by an appraiser. And as previously noted, the owner of the property can accept that amount or reserve its rights to file a claim seeking additional compensation. If a claim is filed, the court will determine the value of the property based on the valuation evidence presented, which is generally in the form of competing self-contained appraisal reports. An award of just compensation must be based on the fair market value of the property, or the most probable price paid for the property by a willing buyer in a competitive and open market. In a condemnation proceeding, property is valued based on its highest and best use on the date of the taking, regardless of whether the property is actually being put to that use at that time. So where the highest and best use is different than the existing use, it must be established that it is reasonably probable that the asserted highest and best use could or would have been made of the property in the near future. This is demonstrated by showing that the asserted highest and best use is physically possible, appropriately supported, financially feasible, and results in the highest land value. So in other words, they're trying to give every benefit to the property owner to get the maximum amount possible out of the property that's condemned. While the condemnee may offer evidence of opportunities for improvement of the land, that proof is admissible only to show its present value and not the value of the land with the improvements made. Finally, land suitable for subdivision cannot be valued as though already subdivided, but rather must be valued by giving an increment in value because of its potential use as a subdivision. The methods of valuation used in a condemnation proceeding are similar to those used in tax assessment cases, and in order of preference are the sales comparison approach, the income approach, and the cost approach. The sales comparison approach is based on sales of similarly situated properties, and adjustments are made to account for any differences. The income approach is based on the fair rental value of the property, not on any capitalized gross profits of the business on the property. And the cost approach is generally reserved for specialty type properties where the other methodologies are not available. Other issues associated with just compensation. So when property is subject to a lease, the traditional measure of damages is the difference between the rent reserved and economic rent, or the rent that the property is worth on the market. So the value of the lease is also influenced by the length of the term, the conditions of the lease, the economic conditions, and any other material considerations which would enter into the mind of a prospective purchaser. The general rule for evaluating damages is to first determine the damage to the fee as if it were unencumbered, and then apportion the damage according to the respective interests of the parties. The tenant's award can be no larger or smaller than the reasonable value of its interest. So where the terms of the lease establish the method of apportionment in the event of condemnation, then those terms are generally controlling. When there are partial takings, right, when only part of the property is taking, or when the condemnor is only acquiring an easement, then the measure of damages is determined by calculating the difference between the value of the whole property before the taking and the value of the remainder after the taking. So this evaluation must treat the property as an integrated whole and not represent separate valuations for the property taking and that remaining. In addition, consequential damages are available for any diminution in value to the remainder as a consequence of the taking. Consequential damages are calculated by taking the difference between the before and after values minus the value of the land and improvements appropriated. So typically, consequential damages are limited to partial takings and are not available for impacts on other lands that are located in proximity to, but not part of the lands actually taken. Finally, where a partial taking enhances the value of the remaining land, the Supreme Court was precluded from taking that enhanced value into account in rendering the award. There are other damages available for fixtures where the economic utility of those fixtures is destroyed as a result of the taking. An owner may also be compensated for unsuitable or loss of access, but mere inconvenience is not enough to obtain compensation. So they actually have to lose access, or access has to be completely unsuitable for the property. Damages may be available for the loss of a buffer area. Damages may be available for advertising structures located on the property. An owner may also be able to recover for commercially recoverable native gas, but just compensation or compensation is not available for aesthetic considerations, for speculative or future uses, for lost profits, for frustration of contract performance, or for goodwill. So in considering a claim for just compensation, sometimes you'll see the claimant bringing up issues that have to do with the government and whether they were entitled or allowed to take the property in the first place, but that's not appropriate for this stage of the proceedings. So when a claim is made for compensation, the judge is only charged with deciding what the valuation of the property taken should be, and not whether the government may have taken the property properly. So when dealing with claims for just compensation, it's important for attorneys, regardless of who you're representing, whether you're representing a property owner, whether you're representing a condemning authority, to understand what your client's objectives are. If you're representing the property owner, then obviously it's to obtain full compensation for the land and any improvements taken. For the condemning authority, it's to ensure that the public does not pay more than is just for the compensation. And sometimes I think that idea gets lost, right? I mean, I think that sometimes condemning authorities are viewed as deep pockets, but really it's taxpayer money that those authorities are using to acquire these properties for public uses. So that's why, you know, it's important to ensure that the condemning authority does not pay more than the fair market value of the property. And then just compensation proceedings typically focus on valuation, and so expert testimony of appraisers is often the most critical part of the case, and sometimes the only part of the case. Sometimes only appraisers are the witnesses who get called in these cases. Sometimes it is necessary to call the property owner. Sometimes there are other experts that might be needed. But expert testimony, and particularly expert testimony of your appraiser, is the most important part of the case. So it's important to know who your appraiser is and to be mindful of what their training and education and background is. So when considering an appraiser, you want to consider whether they hold what's known as an MAI designation, whether they hold any other certifications, what their experience is with testifying, with preparing appraisals for condemnation, with preparing appraisals for specific types of property. You know, you should also have some idea of, you know, their appearance and their demeanor. How are they going to behave on the stand, you know, in front of a judge? What are they likely to be impeached on, and how will they respond to being impeached on cross-examination? The credibility of your experts not only may be, but, you know, will likely be the deciding factor in whether their valuation is accepted as true. It's also important to remember, and this is sort of a foundational maxim of property law, no two properties will ever be identical. So, you know, appraising is more of an art than a science. And so there is a little bit of, you know, leeway that can occur. But keep in mind, when you're going to court on claims for just compensation, that an expert that carefully selects their comparable sales are often more powerful than those experts who are willing to stretch. So you never want to have an appraiser kind of, you know, come up with a new valuation methodology or really make some type of stretch assessment in their appraisal report, because that could impact their credibility, particularly, you know, if they're impeached effectively on cross-examination. So with that, I don't have anything further. If anybody has any questions. So no questions. I thank everyone for their time and attention.